Okay, I'd like to call a meeting of May 13th, 2025 of the Lanark County Land Division Committee to order. Normal couple of announcements. Just a reminder, anybody that has any electronic devices, including a cell phone, we'd appreciate if you'd turn them on mute or turn them off so as not to interfere with any of the testimony that may be given today. If you are making any testimony, please come forward and use the microphones. You'll have to turn them on and then turn it off when you're done speaking so we don't get any feedback or any difficulty. The meeting is being live streamed. Do either of the members or any of the members have any disclosure of pecuniary interest? Okay, seeing none. I have a motion that's moved by Stephen Lewis and second by Doug James that the minutes of the Land Division Committee meeting held April 8th, 2025 be approved as amended. They've been amended to correct a little numbering issue on the minutes. Any discussion on that? All in favor? It's carried. And I have a motion that's moved by Doug James, second by Stephen Lewis, that the agenda be presented as adopted. I would suggest that we would add one additional item on the agenda, and that's a discussion on the next meeting date. So I've just, so I'll approve that as amended. Is the agenda as amended? Is everyone in favor of that? Okay, and I guess Cindy, this is your last day that you're going to be in public presence with us. Is that correct?
It is indeed, yes.
Well, we're sorry to see you go, and congratulations.
Thank you very much. I'm not going far, just over to Public Works, so hopefully there'll still be some interaction and involvement in planning as well.
Would you like to introduce our first application today?
Yes, thank you. So this is a deferred application, application number B24112 for Martin White. And this was the new lot on Highway 7. And this original report and application came to Land Division in December of 2024. And at that time, the committee deferred the decision to allow time for the applicant to work with the Ministry of Transportation with respect to the entrance for the retained lands. MTO had requested that it be removed and that the entrance off of the concession road be used. So there's some back and forthing between planning staff and Mr. White with respect to MTO. The township was also sort of looped into the discussions. The package of materials that were submitted with the application included the emails back and forth. MTO did not change its position necessarily. The township's position confirmed that they are ambivalent with respect to whether the condition stays in or out. They've confirmed that the entrance off of the concession road is suitable for commercial use. So what we have done is prepared the addendum report, which was included in your package, and we have done an analysis and recommending that we grant the provisional consent with the removal of the MTO condition. But we have included the MTO advisory notes with respect to the commercial use of the entrance coming from the concession road rather than from Highway 7. So we are recommending approval as outlined in the planning addendum report.
Okay, thank you very much. And Mr. White, thank you for giving us such a in-depth background, I think is the way I'll put it. I did get through and read it all. I hope my other colleagues did also, but there was quite a bit of research done over the period and the conditions have been revised. Is there anything additional that you want to provide us as far as information, or you just want to answer questions?
So I don't think I actually got a copy, or at least I somehow omitted reading a copy. So this is news to me. So just to clarify, and I've been super busy, so I obviously missed something. So basically the intent is today under that is just to proceed with everything the way it is. And we're just ignoring MTO's recommendation to remove the farm entrance. I'm sorry, I don't know what happened.
So yeah, on Thursday, we published the agenda. We would have sent you an email. So yeah, so basically, I believe in the previous staff report, the condition was number 9 was the MTO. Yeah, so in the previous list of conditions, condition 9 was that the applicant had to satisfy the requirements of MTO as set out in the letter of October 17th. So what we have done is removed that from the list of conditions that we're proposing. But what we have done is added advisory notes that from MTO, access from the retained lands must be redirected to Concession Road 5B from Highway 7 in accordance with MTO policy on alternative access routes. And a second advisory from MTO indicating the owner acknowledges that the commercial access associated with the business located on the retained lands zoned RU 75 is the access from Drummond Concession 5B and not the field entrance onto Highway 7.
Right. So there won't be any closure of the farm entrance that's on 5B.
There will not through the consent process. You can proceed with the consent process without that. Now, what
Okay.
MTO may choose to
Yep.
do in terms of enforcing their policy in the future is a separate
Okay,
application.
I apologize to the board. Somehow I missed that. So sorry to cause a little bit of extra this morning. So I thank you then. Really, there's nothing for me left to say, I guess, but thank you. A little bit of common sense prevailed and I appreciate that.
Did you want to have a look at these conditions or go through them? I think they're all the same as they were previously with the MTO stuff being moved into an advisory notes as opposed to being conditions.
Yeah. Okay. Sure, I can, if I could take a few seconds, that would be great.
Okay, that's fine. Either of the members have any comments?
I agree with the staff report and the staff recommendation. Very briefly, I guess I'm persuaded mostly by the fact that this has existed for such a long period of time. Leave it up to MTO and their own devices if they want to change something that's existed for as long as it has. So I agree with the removal of that condition and proceed with the application.
Stephen, any comments? I think one of the determining factors for me is the fact that MTO does have other means to enforce that provision should they so desire to do so, rather than trying to make us enforce something that they want done. They have lots of other means that we don't have, and I think it, so they still could come back at you, I guess,
Mhm.
Mr. White. That's one thing I'm saying, but I don't think it's fair to make the county be the person that enforces their provisions.
Right. And I think that was for me, that was a part of it. I'm not sure that this Kumar guy even was aware that the commercial entrance has been on the back 5B. I don't think he even knew it was there, period. Because he's never been back there. But through the history of what I wrote to you, MTO has been on that property multiple times. And it's never been an issue. If they didn't know that was there, then they wouldn't recognize the fact that what's on Highway 7 is a farm entrance. And I even brought more literature for you just to show that under the MTO specs in Lanark County, there's a difference between a farm entrance and a commercial entrance. And the entrance on Highway 7 is a farm entrance by definition. It's not wide enough to be a commercial entrance. So thank you. Appreciate that.
Okay, and have you had a chance to look at those conditions that
I have
give you a
now,
copy
yes.
of? You're okay with that? I
Yeah.
mean, the only one that's a little bit unusual is the water line, and I think we talked about that before, and you maybe already got that sorted out, so.
Yeah. Water line? Sorry.
There's a condition in there about the well, because the well servicing both.
Yeah.
Yeah.
Yeah. No, I'm fine with that.
Okay, I think we talked about that before. That's
Yeah.
why I just wanted to make sure that you were aware of that. So any questions from the members? I don't think so. All right, well, I have an application that's moved by Stephen Lewis and seconded by Doug James, that application B 24-112 be approved, subject to the conditions presented in the amended planning report. All in favor? It's carried, Martin.
Yes. I think I have a strong case though, if they do decide, But yeah, that's my fight with them, and I appreciate your time and thoughts. Thank you.
So Martin Christie will send out the notice of decision to you probably later today. So you'll see that.
Okay, Cindy, you want to introduce the appealed application?
Okay, so the next order of business is to review the applications B25-001 to 003. These were brought forward to the committee at the last meeting. The committee, as you will recall, decided to remove the condition regarding the archaeological assessment. That notice of decision was sent out, and the Township of Montague did appeal that as it was against their recommendations. They had asked for that condition to be in there. So we do have the appeal that has been filed. We have sent notice out to the parties that we wish to invoke the alternative dispute resolution clauses under the Planning Act, Section 5327.1. So we're here today to review the possibility of coming to a solution or a resolution of this matter so that we can avoid the appeal. If we are successful today, can proceed with minutes of settlement and have the appeal revoked. If we're not successful, if the committee changes the conditions, we can issue a notice of change of conditions, and that would trigger another appeal period if that's the route the committee goes. So we don't have a sort of a standard report or review process for this. We can just, I guess, start with some discussion and go from there.
Okay, thank you. Do we have anybody else joining us on Zoom for this one? No, so we're all here. Okay, so I'll get you both to introduce yourself and swear you in, Forbes.
Thank you, Chair. My name is Forbes Simon. I'm Senior Planner with JP2G Consulting and Senior Planner of Record for Township of Montague.
And just before I move on, Forbes, do you solemnly affirm that any evidence given by you in these proceedings shall be the truth, the whole truth, and nothing but the truth?
I do, sir.
Thank you very much. And you, sir?
Hi, my name's Sean Kelso. I'm the applicant for the proposed lot severances.
And we swore you in at the last meeting, but I think just we'll swear you in again. Do you solemnly affirm that any evidence given by you in these proceedings shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. Okay, maybe I'll let you go first, Sean, if you have any comments or anything that you want to, comments that you would like to make to the committee when we're reconvening this.
I think just I guess revisiting kind of the requirement. Appreciate the time and attention at the last meeting, and I thought we had come to a pragmatic kind of outcome, but I think that the nature of the severances, they're heavily treed. I think it's unlikely that there's an indigenous settlement or something likewise in the area, and the wetland itself, I think, is mostly marshland. So I don't think it's a high probability or of an archaeological potential, but I'm open to feedback from the committee members and the township.
Are you prepared, if we amend the condition to require the study, are you prepared to do that?
The study's required. I'll have it done. Yes.
Okay, any of the members? Stephen, you have a question?
Stand by my previous decision. I don't think there's a study needed there. The choir book that elected officials are singing from is less red tape, less regulations, less cost, let's build houses. So this is just totally, again, that's the policy I kind of agree with. And I would hope the applicant does take this to the land tribunal to settle this, because this is going to probably come in every friggin' application now that has a wetland. It'll be a precedent-setting thing. I can see it coming where there's archaeological studies 1 and 2 to be done. I haven't changed my mind, and I don't think I'm going to. I'm kind of frustrated about this whole damn thing.
Well, thank you for you got that rant off your chest today. That's good. Doug, do you have any questions or comments, particularly in relation to what Sean has said? And then we're going to let Forbes give
Yeah.
us the township's perspective.
And I guess I'm going to ask Mike the question, what's the difference between an archaeological assessment and an EIS? Why can't the EIS accomplish the same thing? Because we're dealing with a provincially significant wetland here, a PSW. Why can't the EIS do what the archaeological, and I think we're going to have an EIS anyway on this application. Why can't it accomplish the same purpose?
Well, the environmental impact assessment will review the wetland and the development in relation to it and determine whether or not it meets the provincial policy test of no negative impacts, which is the requirement under the provincial planning statement. An archaeological assessment is different in the fact that it has to be completed by a licensed archaeologist in Ontario. And they have to complete them in accordance with the Ministry of Culture and Tourism. I believe that's the governing ministry still. They have standards that need to be applied. And then there's also a submission requirement to the ministry to notify them of the work being undertaken and any findings. So they are distinct studies in terms of both their subject and the qualifications required to complete them.
Okay, I guess then if that can accomplish the same purpose or nearly accomplish the same purpose, I guess I'm going to ask Forbes, why aren't you satisfied with just having an EIS instead of going to the archaeological phase 1 and phase 2 of an archaeological assessment that may not even be needed?
Well, I think, Doug, that they are two different sets of
They are.
rules done by two different sets of experts. And the EIS study has been done and is submitted as part of the package. What the township in this case had indicated that they would allow the archaeological study to be done as a condition of approval, as opposed to, they often require them to be done ahead of time. So we don't normally see whether they're required or not, because they're sometimes asked for ahead of time. And of course, we have a whole lot of applications that get approved by delegated authority. So before we start asking Forbes questions, I'd like to give him an opportunity to make a presentation to us, if you would, Forbes.
Thanks very much, Chair. I'm speaking on behalf of the municipality, the township. I've got direction from the manager to represent them here today. I think that there's a couple of things that were concerning for us. Number one is where you as an approval authority are presented with two planning reports by professional planners recommending that a condition be imposed on the decision, and that condition was not imposed on the decision. I appreciate the sentiments about the current context that we're in and building houses, but I can also say to you that the rural Ontario is not going to solve that problem, and using it as a justification to ignore rules is not appropriate, in my opinion. We have a situation where we have clear direction on the provincial policy statement. We have clear official plan policies as to when these are triggered. And with all due respect to everyone in this room, there's nobody here that's qualified to make the determination as to whether there's potential for archaeology on this property. We're given a screening guideline. We follow that screening guideline, and if it triggers the need for an archaeology assessment, the first step that the archaeologist does is a stage 1 assessment to see if there is merit in this site being studied further. That's the very first thing they do. I think they're the experts. They're the ones that we are supposed to be deferring to, and that's the direction in the PPS and in our official plans. The property in question is part of the Brazil Creek system. It's a wetland. There's many wetlands in Montague Township. And we are constantly dealing with the need for archaeology assessments where the wetland feature is notable, and particularly within the proximity of this land to the Rideau River, which we are all aware was sort of the 401 for the First Nations in this area. I think the other thing that I would like to stress to you is that our initial review of this application identified the need for an archaeology assessment. We identified it as a need for a complete application so that it needed to be submitted along with any other of the studies up front. But then we were approached by the Land Division Committee in December saying, listen, they can't do this work until next summer. How about we make it a condition? And so in the spirit of cooperation, we said, sure, let's make it a condition. Now we get to a point where it's not a condition at all. Just not sure how this is going to facilitate the township moving forward. We're not sure if there's lack of support at the Land Division Committee for written, established official plan policies. We're not sure how we should proceed, how to go forward. It's really critical to the entire process that the approval authorities respect the policies of our plans and assist staff in implementing those policies. Our request is that you change your decision and you add in a condition that's very much written the way the township's condition is written, that an archaeological assessment be done. If an archaeologist comes back at the end of stage 1 and says, that's it, that's it. It's the end of stage 2, it's the end of it. But regardless, they're the ones that are licensed in the province of Ontario to make the calls on these types of matters. They're simply implementing the policies that are established by the province, approved by the councils.
Okay, I'm not just going to say thank you for that, Forbes, because I think the rant was a little unnecessary, but we'll leave it at that for now. And we've reviewed your report. Have you required the same condition on a number of other severances within your municipality?
Yes.
Okay, thank you. And the photographs that we had that were on our report was submitted didn't show the wetland. I don't know if you were aware of that or not, but it did not show a wetland. Your own official plan, I believe, I was told at our last meeting, doesn't show that wetland as being provincially significant. We found out after the fact that the Conservation Authority shows it as that. And I'll ask Mike, do you know how many other municipalities in the county of Lanark require archaeological studies within 200 meters of a secondary water source, being a wetland, marsh, creek, or spring?
The interpretation of those provincial guidance does vary municipality by municipality. Some municipalities have very strong positions on it and official plan policy language that is very clear, such as Montague. Other municipalities apply some element of discretion in how those provincial guidelines are applied.
Okay. And perhaps Montague's has the more current version of what the ministry wants. I'm not saying that's the case because some of the other official plans probably need to be updated. So I think that's a statement that I would give to Montague.
Yeah, that's the case. I mean, really, this all comes from the provincial criteria for evaluation of archaeological potential from the ministry. And, following those guidelines, it does say within 300 meters of a water body, because they suggest that 80 to 90% of archaeological sites are within that distance from water sources. And they do list swamps or marshes as a potential water body of secondary importance. So while there is some interpretation there, some ability for interpretation, I would tend to agree with Forbes in terms of Montague's been very consistent in implementing this as their local policy direction on the matter.
Okay, thank you. Any other
Sure.
comments?
Chair, may I respond to your comments, sir?
Sure.
Thank you. I appreciate that it isn't identified in the township's official plan as a wetland. It is identified in the Lanark County official plan as wetland. And as part of our review, when we're doing these plan assessments, is that we do consult with the Conservation Authority regulated mapping to ensure that the feature that we're talking about is regulated by the Conservation Authority. And so in this case, it's identified by the Conservation Authority, the county official plan, the township zoning bylaw, but it was an oversight in the official plan, and I grant that, sir, but that's not the only source of information that we look at to make the determination as to whether it's a water body that would trigger an archaeology. Thank you.
So are you saying that if it's not a recognized water body, then it would have to, if it's a wetland, it needs to be provincially significant when you would apply this provision? Is that my interpretation of that, Forbes, or am I putting words in your mouth that aren't necessarily true?
Chair, I'm not 100% sure how to respond to that. I will tell you this, that we spend a lot of time doing applications before they come out of the township and come to the county. And that each property is unique, and we look at it as being unique, and we try to apply these policies in a fair and consistent manner. We do have a situation in Montague where the local conservation authority is not doing as required and protecting locally significant wetlands. The Mississippi Valley Conservation Authority does, but the Rideau doesn't. So we have had a tendency to reduce unevaluated wetlands in terms of their prominence, and that they would only be considered, sir, if there's clear connection to other water bodies, or that there's other features on the site other than the water resource that the ministry identifies as criteria. In this case, it's worth noting that it is the property that's in question for the severances is a relatively isolated sandy loam deposit, and that is another trigger, is a sandy loam deposit next to wetlands or waters are to be looked at. And typically, when we're making decisions on archaeology, we look at all the criteria. And so this one, it certainly seemed to warrant at least a review by an archaeologist for stage one. Not all archaeology goes to stage two. Quite a bit of it does, but not all of it.
Well, I've been involved in quite a few of those reports over the years, Forbes, and I haven't seen any that didn't go to at least stage two, and most of them went beyond. But I'm not saying that it wouldn't necessarily be the case. The rules are there, so they can be less. Any other questions from our committee members?
Just to comment, and I go back, I guess, to Mr. Kelso, and the time and the expense of an appeal, if Mr. Kelso is faced with that, is he just simply going to say, I agree with an archaeological assessment? And if that's the case, then we might just as well do it at this point and avoid the time and the expense that the applicant and the township are going to have by going on with the tribunal. But in 6 or 7 years of my involvement with the Land Division Committee, the archaeological assessments, studies have not been prominent or even noted as far as numbers are concerned before this committee. And one of our purposes as a Land Division Committee is to have continuity through the county. And I don't see that this has been a a priority as far as the other townships are concerned, to warrant the archaeological assessment at this point. But again, I get back to Mr. Kelso, if he's going to knuckle under and go along with the archaeological assessment, if that's his decision, why not end it here today? But I don't want this to be set as a precedent as far as our committee is concerned, that we're going to get into archaeological assessments where they simply aren't needed, and other townships aren't buying into it as far as the county is concerned.
I don't think we can look at provisions in an official plan as being precedent setting. I mean, that there's been a process that's went through to have that adopted within the official plan, and Forbes has made his points in relation to that. Stephen, you have any questions or comments?
I think it's not needed. I think it's overkill. I just can't believe it's even being asked for. And like Doug said, I guess it's up to the applicant whether he wants to accept it or not. And I guess my question will be, if we go to a land tribunal hearing, does our staff represent our point of view?
So, you know, we did sign off on the report that included as a condition. That doesn't necessarily mean that I can't, on review, represent the committee's position that in this case is not warranted. But honestly, I'd have to take a closer look at it, look at the historical air photos, determine whether or not, you know, it's been a consistent wetland in that location. You know, and look at the other factors to consider as well. You know, there's no size criteria prescribed by the ministry for the wetland and the adjacency to it. But, you know, my first blush would be that perhaps it's intended to be, as Forbes has also mentioned, a wetland that's part of a larger complex that might have had some foraging characteristics or something large enough to make it, you know, an itinerant or seasonal settlement area likelihood. So there's a lot of things that would go into it. I would certainly, as a member of county staff, give it a fair review to determine whether or not I can professionally represent your point of view. I think there is merit, you know, to your position that perhaps this one is just disconnected and minor enough that it isn't warranted, but I wouldn't be able to do that determination without a holistic review.
Okay, thank you.
I think from my position, our disagreement shouldn't be with the applicant or with the township. If it's the actual province that has put in that 200-meter requirement, which Mike has told me that they have, then our issue should be with them. I find it very unusual and very concerning that we got a provincially significant wetland that's been designated. We've got organic soils on the property, and yet the Muncast report says we're 130 meters away from the wetland, so we don't need to take that into consideration in our EIS. But we have to do an archaeological study because we're 200 meters away. Like it would seem to me that there should be some relevance in those setback requirements. I'm not sure which one's right, and it doesn't matter. Mike.
Yeah, I think at the end, this comes to, there is provincial policy, and, you know, there's a professional obligation on all our parts to, you know, ensure that we're being respectful of, you know, the goals we're trying to achieve here and understanding our history on these sites. But, you know, I think it's undeniable at this point anyways, at least from the information we're getting from staff, that, you know, while we consider the provincial interest, we also have to give credence to the local public interest. And it seems, and unless Council of Montague gives direction otherwise, that they believe that archaeological assessments are squarely in the local public interest, that they want to see them done in very strict accordance with the provincial guidelines, or that's the message that we're getting from the representative here today. You know, so I think we do need to weigh that in all of this. There is the provincial guidance, but then there's also the local council's interest. So, you know, unless the local council suggests that they want to have some interpretation of that policy and gives direction to staff, you know, that needs to be weighed out here as well. You know, local public interest is an important factor to consider.
Okay, thank you. Forbes, did council pass a resolution approving the appeal?
No, not at this point in time. It was the direction of the manager of the municipality. It was reviewed, I believe, with the Reeve and Deputy Reeve, but it's not council. And the reason we haven't taken it to an in-camera yet is because of the approach that's Mike's suggested, and that we were probably going to council after this meeting.
So I'm a bit confused. Mike, can the municipality staff make an appeal, or is the appeal made by the council of the municipality?
Municipality staff can, they'd want to make sure that they have the appropriate delegated authorities in place, either in practice or in by bylaw or resolution to do that. But certainly it doesn't have to be an appeal filed by a council. They can be filed by a representative, as long as they have appeal rights, which municipalities do. You know, and maybe that's if this comes down to a local public interest and a very strict interpretation of their official plan and the provincial public interest, maybe that's the middle ground here, is just for the committee to give direction to include the study, subject to the local council ratifying that indeed that is their position on this question. And then if that's the case, then we can execute the minutes of settlement, and staff and on a delegated basis can update the condition. If that's what this file hangs on is the local public interest, then maybe hearing from council to confirm their position is the best way to do it.
Okay, and if there's already been a couple of members of council that have spoken with staff, then that probably is something that's fairly doable, I would think, Forbes, to get a resolution of council. That seems like an appropriate middle step, perhaps, for me. I'm opening to comments from my committee members. Doug?
I have no further comments than what I've already said.
Stephen?
Did you say, Mike, that we have to approve the condition and then it goes to council? Why do we have to approve the condition? Just let it go to council, and if they want to do it, do it. If they don't, they don't.
No, so you have essentially, well, I think you have three clear choices kind of in front of you. You can suggest that no amendment to your decision is going to occur, and then it will be up to Montague to determine whether or not they continue with the appeal or withdraw it before the window, the 75-day window, for this alternative dispute resolution to occur. You can make a direction to staff today to amend the condition and have the party sign minutes of settlement to give effect to that, which would then have, as a condition of that, Montague would withdraw their appeal. They essentially agree that the county staff will change the condition, and because of that, Montague will withdraw the appeal. That's what would be reflected in the minutes of settlement. But I thought a middle ground here, if this file hangs on what is the local public interest, how strictly are we going to enforce the ministry guidelines in this case? Then the middle ground might be to say, give us that direction to add the condition to include the study, to execute minutes of settlement, but make it subject to the local council confirming their position. So you don't have to dialogue with the local municipality, but if this hangs on a question of local public interest and you're concerned the council isn't fully read in on this file, you could always suggest that occur.
All right. We've seemed to have asked all our questions and done all our considerations. Stephen, do you have any more, or are you done?
I'm satisfied with that. I guess I think everybody knows my position quite well, but I guess it boils down to does the Montague Council, is it important enough for them for put the time and money into it, or Mr. Kelso on the other side? It's let them figure it out, I guess. Am I right? Is that not the proper analogy? I think so.
Yeah, I hate to see a development proposal held up waiting for a hearing, and which the probability of winning at that hearing, I think, is less than 50%. I don't know what the actual number is, but I think that, Forbes has made a fairly strong point. So I think that, we could be held up waiting for a hearing date, an expense of going to a hearing, probably having legal representation by all three parties. Doug would appreciate that. The lawyers would get richer, but I'm not sure that really solves anything. And at the end of the day, may well make a requirement to do the study anyway. So I'm happy to amend the condition, prepared to request that the township demonstrate their support of the amendment in the form of a resolution. But I don't need to do that either. So I'm open to suggestions. Doug?
I have no further suggestions. I'm amenable to your suggestion that you've just stated.
Okay, so I have a motion here that's moved by Doug James and seconded by Stephen Lewis, that the conditions set out in the notice of decision relating to the applications B 25001, B 25002, and B 25003 be amended to require the archaeological assessment to the satisfaction of the township and to include any recommendation mitigation measures in a development agreement. And further, that Secretary Treasurer be directed to enter into minutes of settlement with the parties who are agreeable to this amendment to facilitate the alternative dispute resolution process under section 53 brackets 27.1 related to the Ontario Land Tribunal appeal. That's the motion I have in front of me, that's been signed. Do you want to amend that motion?
One we want, at least not the one I think we want, that's saying we've changed to put the condition in.
That's correct.
I don't agree putting the condition in. I say, I wanted to do was go to the township council, let them decide whether they want to put the time or money into it. And if they do, then Mr. Kelso can change his mind at that time, or let Mr. Kelso and the township decide it.
But I think the way the process works, and Mike, you can help me on this one, that we're the ones that would change our condition for minutes of settlement. I don't believe it would be between the township necessarily and the applicant. Am I wrong with that, Mike? Or?
Yeah. If you want a confirmation of the local public interest, so basically you want council to back this position of requiring archaeological studies in relation to wetlands in cases like this, then I think all you would do is add another clause and just say further that this be subject to a confirmation of the local public interest by Montague Council, and it wouldn't be a resolution, because if it's discussed and closed, it would just be direction to staff, but we would know that it had occurred. If you disagree with including the condition, then I think the motion should still be put to the floor and you just simply vote against it. And if there's two that vote against it, then the current decision of the committee stands. Now, I don't want to forget that Mr. Kelso is the applicant here. If this is amended and the condition is changed, I would say this is not a minor amendment. It is a major amendment, which means there would be a notice provided to basically the parties in this room. And Mr. Kelso then has the right to appeal it as well and say that, no, I don't want this condition added to the file. So everybody here will have an appeal right one way or the other. It's just whether or not they will choose to exercise it. But if you want Montague Council to validate that indeed this interpretation is their position and this is the local public interest in the township of Montague, I suggest you add that third subject that just say this be subject to Montague Council ratifying this or Montague Council verifying this as their interpretation of their OP policy.
Doug, any thoughts?
I think it's a good solution to add what Mike suggested into the condition. And if that would satisfy Steve, then I'll go along with it.
So I would need an amendment made to the motion that you guys have signed and approved. And I would want both of you to make that amendment so that you would have to, one of you would have to move that amendment and the other one would have to second it in my mind, and we could vote on the amendment and then on the overall motion.
Also move.
Do I have a seconder? You'll second that? And it hurts, eh?
I'll second it without the warm fuzzy feeling.
Okay, so without trying to read it again with all that in there, I think, do you have that wording added to the end of the motion for us? Does anybody in the public need that read again? I think we've discussed it enough. Okay. So all in favor of the amended motion? So it's carried. Thank you.
Thank you very much.
Thank you.
Well,
Okay, so we have item 9, which is communications, and I think that was a report from Mike. I've read through it. I don't have any questions on it. Does any of the members have any questions on it?
No,
Nothing further, Mike? I mean, I think it was just for information, right?
No, there should be a resolution sorry, is this the one about the appointment of the secretary treasurer?
Yes, it is.
Yeah, there should be a resolution to appoint the clerk for Lanark County as,
My mistake, I forgot to do the written resolution, so we
Okay.
can do it as a verbal. My apologies.
So is that something like, I thought county council appointed that position, or is it something that we need to do?
yeah, so county council traditionally has by bylaw, but when you look at the act, it's actually the land division committee that's technically statutorily authorized to appoint their own secretary treasurer. So what I'm suggesting is we appoint the clerk, and then the clerk can, under the municipal act, give authority for that delegation of authority to anybody in writing. And so that way, no matter what staff changes occur, if an employee went on an extended leave, we wouldn't be left in the lurch and having to go to council and get another bylaw passed to give somebody else the authority. The clerk can simply sign it over to another party. It gives us greater flexibility.
Makes total sense to me. So I would need a mover and seconder of a motion to appoint the clerk of the County of Lanark as the secretary treasurer of the Land Division Committee. Could I get a mover for that? Stephen Lewis and a seconder, Doug James. Got all that wrote down, Cindy? Okay, all in favor? That's carried. So I think our next item to talk about would be the next meeting date.
Yes, as far as I know right now, looking at our applications, we don't have any applications currently that are sort of put into the land division bucket. So we don't have any that we know of right now. We are starting to get a lot of the comments in from the agencies, so I'm expecting that there'll be a few more that we can look at. But I'm not seeing anything on the immediate horizon. But I think it's wise to set aside a date if we could, as I know there's some availability issues with the committee. If we could look at dates maybe towards the end of May or no, this is May, end of June, or I know we don't normally meet in July, but if there's some date in there that would work, just to have a placeholder in case there is a file that or an application that comes in.
Well, I'd like to suggest June 24th, if that meets the requirements of the rest of the staff and of the other committee members. Would that work for you guys? Doug, yes? Mike?
good for me.
Michael, does that work for you? And Cindy, I guess it doesn't matter. You're bailing out on us.
Well, like I said, I'm not going far. I may come back and forth depending on, I don't know if they'll have a replacement hired at that point in time. So if I can facilitate that meeting, I'm more than happy to do that.
Okay, thank you. So we'll have that date changed. I don't think we need a resolution. I think we can just discuss it and have it done. Anything further on the meeting?
There is nothing from my end, no.
Okay, so it's moved by Doug James and second by Stephen Lewis that the meeting does now adjourn at, I guess I'll call it 10:50 a.m. All in favor?